Head Note A. Culpable homicide not amounting to murder. Guilty intention versus guilty knowledge. Determination. Framers of the IPC designedly use the two words intention and knowledge. They connote different things. If an act is done by a man with the knowledge that certain consequences may follow or will follow, it does not necessarily mean that he intended such consequences and acted with such intention. Intention requires something more than a mere foresight of the consequences. It requires a purposeful doing of a thing to achieve a particular end. Head Note B. Culpable homicide not amounting to murder. Single injury. Guilty intention versus guilty knowledge. Determination. Disease did not allow appellant to use disputed pathway to transport harvested crop. Verbal altercation took place, and appellant hit a blow on the head of deceased with weed axe, common agricultural tool. Knowledge of the consequences, which may result in the doing of an act, is not the same thing as the intention that such consequences should ensue. Difficult to come to the conclusion that appellant intended to cause such bodily injury as was sufficient in the ordinary course of nature to cause death. Appellant could only be attributed with the knowledge that it was likely to cause an injury which was likely to cause the death. Case does not fall within Clause 3 of Section 300 of the IPC. Conviction under Section 304 Part 1 of the IPC alter to under Section 304 Part 2 of the IPC and sentence of 10 years alter to a period of 5 years. Head Note C. Culpable homicide not amounting to murder. Single injury. Guilty intention versus guilty knowledge. Determination. Injury is sufficient in the ordinary course of nature to cause death. Fact that the act is done without premeditation in a sudden fight or quarrel, or that the circumstances justify that the injury was accidental or unintentional, or that he only intended a simple injury, would lead to the inference of guilty knowledge, and the offense would be one under Section 304 Part 2 of the IPC. Head Note D. Culpable homicide not amounting to murder. If the act of an accused person falls within the first two clauses of cases of culpable homicide as described in Section 299 of the IPC, it is punishable under the first part of Section 304. If it falls within the third clause, it is punishable under the second part of Section 304. In effect, therefore, the first part of this section would apply when there is guilty intention, whereas the second part would apply when there is no such intention, but there is guilty knowledge.